call together the Board of Appeals, the August meeting at 7:31 here in the town of Bloomfield. We have a couple items on the agenda to discuss. Before that, we don't have any minutes.
No.
So no minutes to approve. We do have a couple of decisions that have been recently put forth. One came from Attorney Kimball today. Everybody get a chance to review that.
I read it. No, I'm fine.
Okay, we have no issue with that. Okay, how about the other one, which was the, do you have a copy to sign on that one? Or what do you have? What you got? The, Apple something like that?
Yeah, I read it.
Yeah, I wasn't 100% happy with some of the point. I think they have the details.
You know, the one, first part is
Yeah, it's a little different than what we use for other licenses. Okay, so the Tuck Residential is signed, we have some other, Abu or something like that.
That's the,
That's here too. So the first case we have is 1613, Damian and Ann Glenn of Lantern Lane. Somebody here represents the petitioner. Okay, please identify yourself. I have
Damian Glenn, my wife Ann Glenn, we reside in 11 Lantern Lane. We're here this evening to request a variance on the front setbacks. We would like to add an addition. Currently, the plans of the addition encroach the setbacks on the front left side, about 23 inches. We have a 4-bedroom at the moment, and we will have 4 bedroom once we finish the addition. One of the bedrooms is a 10 by 10, which is pretty small for what we use for. My hardship is the lot shape, the way it lines up with the cul-de-sac at Peterborough Street. There's a curve right at the front of the house, so that's where we're kind of getting tight with the setbacks.
so I have a question, like I looked at all your plans and all that. Can you just step up? This is the front of the house, right?
Yes, this
Because
is
I
the
looked at
front.
the other plan and it's kind of confusing.
This is the front right here.
That's the front or
This is the cul-de-sac here.
That's what I was saying, it's not cheap because of the design.
See the shape of the lot here?
Yeah.
And it's only for about, I'd say about 2 feet over here, 4 or 6 feet over here, 38 here, and that, so it's about, only about, I'd say 2 feet in that direction.
I think because see, that's the front of the house right there.
Exactly.
Okay.
So it's a frontage issue. Voting on this case, be myself, Pat, and Janice. So, Pat, did you have anything?
I guess the only question is, would it be possible to put that addition on with the nearest wall to the street being 40 feet? Like, how much does that eat into the front?
Yeah, it eats in quite a bit because we're adding a bedroom to make it a little bit bigger. And we have plenty of room on the width to line up with the existing house. So in order to make it a decent sized bedroom and a decent sized bathroom, we'll only have a 12'6" bedroom, we'd say, going from the existing house to the street. So we'll shave it back, we'll be down to 10'6", but we have lots of length on the front of the house. It's not affecting the setbacks.
So I was going to ask the same thing.
Yeah.
Couldn't you move it over a little bit? What's that right there? Can you move it over like?
Now this is the front door, right here. Right here is the two-car garage. So it's lining up perfectly with this existing two-car garage. This is actually a front part of the existing house. So it would actually take more of us.
Could you put it on the other side?
No, it's the dining room.
No, in front of you.
Right here between
Yeah.
abutters here that want to speak to this case? No? Okay. I did have one question for you while the building inspector here may be helpful as well. What I actually was considering is, let's step over here as well. This is a new path that you got?
This is in the existing,
See, it's within the existing footprint, is that changing this, something else now?
yes, this is a garage.
Okay. So, bathrooms have to be vented, right? Are you going to venting as well?
Yes,
In
we
the middle
will.
of the house?
We will have, yes. The choice is going this way,
Yeah.
so we will want to advance directly out.
The outside.
Exactly, we can actually go either way.
All right, I didn't really have anything else. Guys, have any further discussion or somebody prepared to make a motion?
So basically, the budget is,
Check it out.
do you want me to,
Yeah, I would. You don't have counsel, right? Okay, the general policy of this board is when one has counsel, we ask counsel to write the decision. So we have a choice, since Janice is going to make the motion, she might be prevailed upon to write it for the board, unless you felt you wanted to write one for yourself, you could give you a template of the previous decision, but it's a question of, would you get to it fast enough, Janice?
how fast is it?
Yeah. Okay. Well, what we can do is we can correspond through Winnie. If Janice isn't able to do it, she'll
I'll
talk
try to
to her.
get it done.
And let you know.
Otherwise, we can do it through the template, which shows the layout.
Yeah, it's kind of like a cut and paste thing. It wouldn't be too hard to do, but,
I'll try to do it very soon. If not, I'll let you know.
Thank you.
Okay?
get the attorney to do it after she makes a motion.
And motion on case number 16-14, oh, excuse me, 16-13, Union and Union Inn, 11 Union and Enfield, Mass. To allow for a variance under section 10.8 for a front setback for an addition per the plans submitted. By Donald Leonard. Do I have to do that? Yeah, Donald Leonard. Plan submitted to this board by Donald Leonard, an architect of Massachusetts, Pittsburgh. And the date of the plan is. Yeah, that date is not.
It's okay, we
Yeah,
can do
okay.
that. We only have one, so it's not.
I have like.
We only got one from them, so.
Okay. So I motion that we allow that.
Second. Okay, all those in favor? Aye.
Aye.
We have a unanimous decision. Congratulations, good luck.
Thank you.
Okay. Second case we're about to hear is case 1614, and it's Alexander Styler of Needham Road. Does somebody represent?
Yes, Wendy is a investor.
I just want to know that you're here. First, this is an enforcement issue, so we'd like to start off with the building inspector who retains the bulk of our enforcement responsibilities. And so Jack, could you tell us the nature of how this came about and why the letter was sent?
The letter was sent on May 31st, 2016, in regards to the premise at 8 Needham Road, on using the premise as a lodging house / hotel, boarding house, whatever you want to call it. The enforcement order came from, of course, the newspaper, because it was another matter that the Board of Selectmen notified me. I investigated the use of the building. And at that time, we sent the cease and desist on May 31st, 2016. They are not using the house as a single residential use, which is more permanent in nature than lodging, which is transient, which which means probably less than 30 days. So cease and desist order was sent.
Okay, and I think we're all in receipt of the response from the petitioner. I don't think we need to go through all the chapter and verse, but we hit the highlights in terms of the issues you had with the cease and desist.
Sure, I think an overview will do it. Let me say first that it wasn't mentioned, although referred to, is that obviously this all started by traffic that occurred in Lincoln. Interestingly enough, that function really doesn't fit within the concept of logic of college review, but I don't think there's any doubt that we recognize that those sort of things can happen, not just what happened relative to the tragedy itself, but the parking and issues like that. And I've communicated after discussion with the client, there is no intention to engage in that sort of rental. I think you can see from the facts that what this asylum has done is on a very sporadic basis, 4 times in 2015, when he's been on position in rental property. I am aware of this relatively reunion, and there also was one rental that involved movie center or production. But it's been very, very limited over the last couple of years, very sporadic and tied to his own location. Now, when this happened, I contacted, I didn't speak with the inspector first, and I did leave a message, and we got it, and I had a chance to talk to Attorney Mullen as well. Our natural inclination was to immediately say, we understand why we're here, let's explore the issue of special permit. The difficulty with that is twofold, and we'll need to be frank about that. One of your selectmen, apparently referred to this matter, made statements in the press without seeing any application for a special permit or being aware of what it was being contained, indicated that that would be permitted or would be. So, in terms of that selectman, we are entitled to his feelings, but that raised concerns for us. In addition, Inspector Roberta has referred to this as a hotel, which I don't think is appropriate, finding it's a hotel. We can't technically get to a special permit. So, the ground to try to resolve this type of issue, which you clearly should be concerned with and understand, is really not there in our class in the context of a sort of an event that caused everyone a lot of concern. But having said that, we have filed an appeal, and I have had a chance to look at Attorney Mullen's responses as well. In looking at your zoning bylaw, what has been written by this town, you provide an exception to the regular renting of rooms or provision of taking the word 5B. That's expressed right in. You've adopted definitions. One which indicates that the renting of a single unit will not constitute boarding by adopting building codes. You've adopted a definition of family to specifically exclude boarding houses, lodging houses, hotels. Your hotel, and hotel is an important issue, right? It just shouldn't be in my view, but the hotel isn't within the express definition. So we got here because there's really no avenue to pursue what should be a well-managed resolution of this. But the argument we take is a technical one based upon your law. I would say this. Attorney Mullen, in his letter to you, which I'm sure you've seen, has made a point to call this serial commercial activity, which I think is not serial. Certainly commercial. I mean, if a resident here rents a house for 30 days or 6 months services earned income in a tax concept than rental unearned income. Mr. Schuyler is not doing this in a serial way. But the argument that was raised by Attorney Mullen relative to your accessory use was, it's serial over here. It's not regular. And then he suggests that if it's irregular or infrequent, you get qualified as a private workflow. So, what I would like to see Winfield is if they want to control this type of activity, then pass the appropriate bylaw that focuses on the limited rental activity, as opposed to attempt to stretch this in. Make it possible for us to consider working with the town in the context of a special permit, if that's what the town decides to do. But based on what you have accepted, you have to do what Attorney Mullen suggests. You have to fall back and read your own laws based on your intuition. And that's in the letter. Intuitively, he says, we would say anybody who's renting it out for 2 days or 30 days to be involved in a commercial activity. Well, this covers somebody who wants to go to Paris and exchange rooms. I mean, it's potentially that you could stretch that far. So I certainly would ask you to reject the enforcement order for Inspector Roberta, but I would ask you to specifically address the issue of hotel. I would ask you to specifically address the issue of the 5 units. And I think what we can say is that we do want to stand by our rights, but we do want to work with Winfield as well. This shouldn't be an issue on going forward. And aside from what you should be concerned about and we should be concerned about what happened on May 29th, there isn't any desire to create a problem with that. So I would ask you to do that. Thank you very much.
Okay, thank you. Sitting on this case tonight will be myself as the chair, John, Pat here. And just since we have people I don't think have been to a ZBA meeting before, I'm going to give a little preface to how it works. Both my cohorts here are attorneys, so they're well aware of the definitions of law, explicit versus implicit, shall versus may, that sort of thing. So definitions are certainly something that need to be dealt with. I myself am the assistant director for the compliance group of the Department of Defense, so I deal with lots of lawyers all the time, interpretation of federal law. So for those who are new, welcome, thanks for coming, showing your community support. The ZBA is what's called a quasi-judicial body, and while appointed by the selectmen and charged to interpret the bylaws, they're also charged with adjudicating matters where there are not explicit definitions or relief needs to be provided from those given laws. The governance of the ZBA is dictated by state law and further guided by court decisions. The ZBA is specifically charged as a, quote, agency authorized to make rules and determine contested cases. Such decisions are often regarded favorably by the courts unless a decision demonstrates the ZBA acted beyond its discretionary powers, used those powers, or acted in a whimsical, capricious, or arbitrary manner. This board has had one contested decision in the 7 years that I've been here, and that was ruled in favor of the town. I say that because we need to have a little further background. ZBA is also responsible for the enforcement of zoning bylaws, with the building inspector being the primary enforcement agent. The ZBA can reject, uphold, or amend the actions of the zoning enforcement officer. Since this petition relates to an enforcement action, it's essentially an interpretation of the applicable law. Emphasis on interpretation. As such, the principal input involves the building inspector and the petitioner. So, thanks for coming, but there's little need for a butter since they are not really a party to the enforcement action. There can be an inference such participation confers legal standing which could complicate things were this to go to a higher level of proceedings. Legal standing has been a subject of strict interpretation by the courts, so it would be imprudent to apply a lenient definition to that at this juncture. So we'll try to keep any and all comments pertinent to the law at hand in any interpretation made by this board. If this was for a special permit, which was referenced by the petitioner, such as to operate a lodging concern, then the abutters would have full voice and we would call for that same input. So I do have one question for either the petitioner or any of the neighbors, the direct abutters that were informed by letter. Is there any sort of homeowners association or other legal entity that governs behavior within this neighborhood? Nobody contests that, there's no homeowners association or anything else like that? The reason I say that is that the applicable law has been appealed to two states at a much higher level. One ruled in favor of tighter restrictions and one ruled against it. Both of those cases were situations where there was a homeowners association and the interpretation was whether or not they had violated that. Couldn't find too much, I couldn't find much that talks about the precedent or further definition. There's a lot of issues on short-term tenancy and other things of that nature. One thing I wanted to point out is that we have not too much precedent here in Massachusetts for going beyond the zoning laws. Petitioner raised the question that the word family was used, and there's lots of references to family, including some appeals brought up to superior courts that said that definition of family is really seen as a moving target by the courts. The rules and comments are relevant to family are perhaps not the strongest place to put much of a strength on this. So that's the ground rules. If anybody is to be recognized, they're recognized by the chair to speak, and we'll have a time limit on that, and I will call if it gets on or off topic, we would stop it. Again, I don't see too much need for conversation, but we do need to look at a couple of other points, one of which was raised by both the building inspector and town council, and I suspect perhaps our two cohorts here may have done some research as well. So I'll start with you, John. Did you have any comments or questions to either the petitioner or the building inspector?
I was just going to speak as to the petitioner's comments earlier relative to the fact that we're here because of the tragedy. Unfortunately, the tragedy happened. I don't think that's the overriding reason that we're here. It's more of a question of notice of tragedy happened to bring about a notice to the building inspector who has to follow the zoning bylaws and interpret the zoning bylaws. And part of that notice of this tragedy made him aware of this particular circumstances as far as the renting and leasing of this particular property. The same thing could have happened in the event that somebody was using a single-family residence as a multi-family residence or an in-law apartment without appropriate permitting on those instances. So I don't want to hang up too much relative to the tragedy. It is a horrible thing. I feel horribly for the family that's involved in it, but I think it's more of an issue of notice as far as the building inspector is concerned, not as sensationalism relative to the tragedy. The second matter that I wanted to speak of is as far as the limited and sporadic use, and I understand the testimony of the petitioner as far as that's concerned, and I also understand what the chairman's saying as far as testimony of any of the abutters that are here, but I think that testimony may be necessary as far as limited and sporadic use is concerned, and I'd like to hear from people as far as those matters are concerned. Okay. And then the only other point that I wanted to make is you've had an opportunity to look at town council's opinion to us. We actually had asked them that for specific purposes that you would mention, where our zoning bylaw is not 100% clear on that. I think that's done wonders as far as my reading of it, and as far as extrapolation with the building, as far as the building codes are concerned. I'm not sure if we need to read that. Do we need to read any portion of that in, or is it just enter into the record as far as
From the town council?
yeah, it's done part of the record.
Comes part of the record.
Okay.
Petition has a copy as well. Pat?
Yeah, I'd like to at least state the way I'm looking at the issue here, and I'm interested in whether Mr. Mullen or Mr. Reardon agrees or disagrees with this, because my frame of discussion. There was a lot in Mr. Reardon's brief about whether or not the renting of the house on Airbnb constitutes a lodging house or a boarding house. And I'm not sure that's really relevant to the matter, because if it does, it can't be done without a special permit, which really does not exist. Even if it isn't a boarding or lodging house, you can only make use of the property permitted by 4.1. So even if the requirement to get a special permit for a rooming or a boarding house doesn't apply, you still need to be able to hang your hat on some permitted use. If you alluded to 4.1.10, I believe, that reference accessory uses, there's a reference there in 5.1.5 to renting out rooms or a table. So to me, I think that's the issue, as to whether or not the use would apply as an accessory use permitted under 5.1.5. And I don't view the issue of whether it's a boarding or lodging house as relevant, or multitude being corrected by misinterpreting something.
May I respond to that? There is an issue. Notice, we're here doing an enforcement order based squarely on characterization of hotel, lodging house, and room units. So having that separate ground, I think I would disagree with that. I have pointed out the accessory use, but my petition is appealing a specific order of the building inspector that didn't stake any claim now to any uses relative, for instance, to the residential districts and things of that nature. But I would just point that out in the notice book.
Yeah, I'd be interested in Mr. Mullen's view on whether or not the board can uphold the enforcement order from Mr. Roberto on any grounds.
Yeah, my name's Tom Mullen, I'm the town council. I believe so. I believe that the board can uphold the building inspector's decisions.
Please speak up. This is a microphone. We just can't hear anything you're saying, so it's not your problem. Besides the room.
Can you hear me?
Thank you.
I'm Tom Mullen, I'm the town council, and I believe the board can uphold the building inspector's cease and desist order, even if it does so, as I recommended in my opinion that you do, on a basis other than that set forth in the building inspector's order. If you determine that the what I call serial short-term rental use of this single-family home is not a use that is allowed under our zoning bylaws, it seems to me you cannot overturn the building inspector's decision because you have decided, as he did, that this is not a use that may continue. That you may disagree with him as to the rationale is really neither here nor there. You can set forth in your decision whatever rationale you choose. And I think that the building inspector, in his decision, did refer to the problem here as being that the property was available for lodging purposes on a short-term rental basis. And that, of course, is the problem that I identified in my opinion. So I don't think that there's really any notice issue here. I think the property owner was put on notice that there is a problem under our zoning bylaws with the short-term nature of the rental of the property.
So, Tom, would you repeat the statement you have in the letter relative to the definition of transient house limits, since that's what you're referencing?
Sure. Look, basically the problem is this. We all recognize that in Linfield, in the single-family zone, you can have a single family living in a single family house. That's what single residence is all about. And we don't care whether you own the house or whether you rent it. In fact, legally, we can't care. However, while it's one thing for a family to rent a single family home for a year or two or three, it's quite another if somebody buys that home and then rents it out to a different user every couple of days, which is potentially what could happen here, because even if Mr. Styler's use has been sporadic, what he's contending for is the right to lease his property, the whole of it, to one family, one person at a time, for as little as 2 days at a time, and not more than 30 days at a time. So the question that as I see it is, under our zoning bylaws, does the, what I call serial, that is one after another, rental for a very short-term period, i.e. under 30 days at a time, of the premises to a single user constitute single residence use, or is it a commercial use? I looked first, I do refer to intuition, as Mr. Reardon said, but I looked first to the terms of the law. Our zoning bylaws do not specify anything about transient versus permanent. They do, however, say that if there is any ambiguity or if there are undefined terms, then you look to the state building code. The state building code in turn refers to the international building code, and there we see a distinction drawn between permanent and transient. Transient is up to 30 days. Anything over that is deemed non-transient or permanent. So I think that construing our bylaws properly, there is an intent to distinguish between transient occupancy, which is not allowed as of right, and something else, something more permanent, which is contemplated to be allowed. I find some support for that in an extremely recent land court decision issued within the last couple of weeks from Nantucket, where a property owner, a developer, purchased a residential cottage and then proposed to renovate it and lease it out one time after another to a series of renters who would occupy the whole thing. And the case rose or fell on other legal issues, but what was interesting to me is that everybody involved, including the judge, understood that what the developer was doing was moving from a residential use to a commercial use. And of course you can't have a commercial use in our single residence zone. So that was the gist of my argument, of my letter. I'll try to answer any questions you may have, but otherwise I'm content to rest on it.
Pat, anything? Janice, yes?
I have some questions. Is it Mr. Stiller?
Microphone.
Stiller, okay.
The microphone.
Okay.
Hold
So
on,
Mike,
Hold on a second.
Microphone.
are you kind?
Hi, I just have a question for Mr. Stiller. Of course, the Styler, okay. When Mr. Stiller rents his house on short term, does he reside at the house? You've never resided during any rental period? Pardon me? You move out, okay. And my next question is to the attorney. How do you distinguish your Bonaventura case from Judge Long's case, which is Corey v. Rector? How do you distinguish those two cases? How do you distinguish Judge Long's case from your case?
Well, my case is related to the definition of logic, where logic is, and the discussion about multiple people, but in terms of the court case, the Judge Long case, I understand that Attorney Mullen is the lawyer using an insight, but let's look what happened in that case. The person was building an inn. He was building an inn, and they granted a special permit actually gave him a special permit. That other grant that hasn't much to do with this is that the court says you can't do it because you're going to hurt the neighbors. And that's how our system should work. That really is how our system should work. It has nothing to do with this commercial versus non-commercial. And if they were bringing a grant of serial, regular, commercial activity by Mr. Schuyler, there's plenty of cases that would support that position. I can give you one right now, in where it was classified as a hotel. They had a different definition than yours, but the focus was to be able to provide other additional services besides just renting the house.
I know, but excuse me, on that case with Judge Long, that case was decided on use. Use of the property.
That case was decided solely on the ground that the use of the property
Right.
would impair the other neighbors such that the judge said, even though the board gave you a special permit, we're not going to allow it.
How is your case, your facts of your case different than that? How are you saying that it could not possibly impact your neighbors?
To be hearing in front of a judge. Because what you'll do, you don't want to get to that question if you rule against us. You know, this isn't where I've even been able to ask for a special permit. My opening comments on this other issue, and I do understand the points about notice, but I mean, we should be upfront about it. I mean, it wasn't good. It was the sort of thing that impaired neighbors. But what we would like that day in court if it came to that. If there were people here who, aside from that one issue, were to come and say, you know, if Mr. Schuyler continues to do this, we'd like to have the right to be able to oppose it. So I would say that would be my response. Let me point out something else, just to follow up on a couple of comments. Attorney Mullen has pointed to transient versus permanent use, but the legal standard, primarily, okay? Primarily transient use, primarily permanent use. This is Mr. Schuyler's residence. Mr. Schuyler hasn't gone over that bridge and got into your commercial activity. He's not running a hotel. This is why I place the emphasis on. All he's done is listed his home. The only difference is the term. You know, once again, I mean, a special permit to control those issues. We can't even get there. So I would point that out.
So why is it that you can't get there? You didn't apply for one, correct?
We can't get there now until you rule whether or not this is a hotel.
Right, but you could have applied for a special permit under 4.1.1, correct? You could have said, this is a boarding or lodging house, and we want a permit to be able to operate.
Sure.
Right, so you keep saying you can't get a special permit, but you never applied for it.
Well, it doesn't mean we won't, but right now, an issue has been raised by this town that we wouldn't qualify in the first place. This is the decision for you, right? It's not an issue of semantics.
Right, but if you apply for a special permit, it's the board that makes that determination, how much you work, correct?
Well, I understand, but this is
So-
the same issue is before you now, so there's no sense.
Yeah,
Like,
although I don't
nothing
think
to-
it's the same issue, because I don't think that the lodging or boarding house is really the issue. I think it's whether or not you can find something under 4.1 that entitles you to use the property the way you want to use it.
Okay, again, I understand your position, and we've made the point. Let me finish with one of the things I can read, is that some of Attorney Mullen's comments into the record. I further believe that the word regular cannot be ignored. In the context, it appears to me to connotate something other than episodic or occasional. Because Mr. Schuyler characterizes his short-term rentals as infrequent, I believe that even if he could be said to rent a room for furnishing and board, that there would be nothing regular about it. No, so, you know, let's be clear, okay? Mr. Schuyler is not here to run a business and rent a house every other day. He is not here to rent a house every other week. easier to do exactly what Attorney Mullen is indicating, to infrequently do this. So, and again, understand your position, but legally, there's a variety of cases that have dealt with these issues. You know, it comes down to the responsibility for you guys to write the appropriate definitions of the law. Now, I understand your concern. All I'm suggesting is write the zoning law. I'm just
So the
suggesting
zoning
we have.
bylaw says that you can rent rooms, and what Mr. Stiller is looking to do is not rent rooms, but rent the whole house. So even put aside the use of the word regular, you've still got to fit what he wants to do within a zoning regulation that says you can rent rooms.
I understand what you're saying, but it's hard to maintain that position in my view if you're going to maintain the opposite. But what do you say? We should now go to regular use, that Mr. Seiler can get by this if he starts to invite more people there with more cars?
No, I'm not saying anything to the opposite of that. What I'm saying is that in order to do what he wants to do, Section 4 says you can't make any use of the property except what's permitted. The thing that you pointed to as being permitted is renting rooms for table.
I understand your position. I think it's legally untenable, but more importantly, I think the issue ought to be done by telling the citizens what they can and can't do, as opposed to taking this and stretching it in that direction. If you really want that.
I don't think I'm stretching it. I didn't write the words, I'm just interpreting.
I understand. And you understand our position as well. I appreciate it. I'm just very, thank you.
Attorney Reardon, as you know as an attorney, I'm an attorney also, that if any bylaws or any laws are absent on any type of issues, that you look to other laws that oversee the local laws. That's why we went to the Massachusetts Building Code and then the IBA. And that's how you, if it's silent, because you can't obviously cover every single issue that comes in the town. But I think the whole issue here is use. And in my opinion, my opinion is, if you had at least applied for a special permit, it would have been another case, and we'd be arguing something different. But I have a question for Mr. Styler. How many short-term rentals has he had within the last year? Short-term meaning 30 days and shorter, within the last year.
I would go to say altogether about 6.
I'm sorry?
In the past year, probably around 6.
6?
Maybe 8 hours.
Okay.
Maybe less, maybe more, but that's about the ballpark.
Okay.
Just to give you a calibration of the situation.
Okay, and even though we're arguing use, I still think that we do take into consideration as well the abutters situation. How close are you to the houses? How many side yard and backyard to the houses, to your neighbors? How many feet would you say?
I have 8 acres of land, more than 6.17 acres. My house is older here, and houses are extremely far away. I can't even see my neighbors. Okay.
Well, we'll probably hear from
I
the
don't know
neighbors.
you guys. Go ahead.
Oh, we won't. We won't hear from the
Oh, you're my
neighbors.
neighbors, okay. Very nice to meet you. Yes. And then, I guess.
Okay, a couple of points I'd like to make by way of definition. The 2015 IBC has a number of definitions in addition to transient. So petitioner was asking us to definitively rule out certain definitions. My opinion is if we don't have a good definition, we may not be able to support the use of it in the cease and desist, but we also then wouldn't have enough to definitively say it doesn't apply because it's not a sufficient definition. So a few definitions the board can consider and might go to the point that Pat was raising. One is by 2015 IBC, congregate living. The definition for that easily is they share bathroom, kitchen, or both. Almost anything could probably be called congregate living. Boarding is with or without meals and not occupied classified as a single-family unit. So by the IBC definition, it doesn't seem to fit that because its primary use is a single-family unit. Guest room definition is one or more guests for living or sleeping. Lodging, however, says it's a one-family dwelling where one or more occupants are primarily permanent in nature and rent is paid for guest rooms. Not exactly explicit to the way the petitioner is using it, since he says he leaves and he's not there, so it kind of stretches. Lodging might be closer to what most folks would see as a bed and breakfast sort of thing, with the expectation the primarily permanent resident, which would be Mrs. Tyler, it's obviously permanent in nature, and he's renting out the space at different times. What was also part, I think, of Attorney Mullins' memo was that IBC further classifies property whereby this falls into what they call an R3 residency, which means that the resident is primarily permanent in nature, and it discusses the idea that you could board no more than 10 occupants, or you could lodge for no more than 5 guest rooms. So to Pat's point, there might be an opportunity, subject to board approval, that if you were to seek a special permit as a lodging house, it seems to fit that definition to a certain degree. I, for one, have a little concern over transient and the definition there, simply because we're in an area where the laws are not well versed out. As I indicated, 2 states have brought this to their own Supreme Courts, not exactly in kind. What it points out, however, is the absence of laws in those states. California is pushing for a number of things similar to this. Most of them are definitions around what we would call short-term tenancy. That's the term they all seem to be using. So to suggest that anything less than 30 is definitely transient, it may be on the books, but it's not enforced any place, and we don't have specific law here in this town except to refer to the IBC code. So my concern is that I've looked into it and saw that cities like Boston and Cambridge also would understand the definition of transient, yet they have a good number of facilities which clearly rent out in a similar nature on a day-to-day sort of basis. So I have some concerns about that. For the record, so everybody could understand, because I think, as Attorney Reardon suggested, and others have discussed here, the lack of explicit definitions is what causes a lot of problems. If you don't have an explicit interpretation explicit enough to hang a decision by the ZBA, then you are prone to appeal at a higher level as well, and they'll be faced with the same discussion. Our own Brad Jones had jumped on a bill that was originally proposed by the House back in December, and the proposed bill in the state of Massachusetts, which was not voted to go to the governor's desk just this week, would have provided, and this is Brad Jones's input into this bill, it would have provided for an opportunity to operate B&Bs within the state of Massachusetts. Don't know if they were defining short-term tenancy or exactly what fits into a B&B, but they're recognizing that places like Airbnb have been compared to Uber as the latest application, which rapidly accrued a multi-billion-dollar valuation, so it's not going away. What the bill would do is to provide for a registration, basically, of anybody who sought to operate such a bed and breakfast out of their home. And what it would do is provide for record keeping by which the owner would have to, and the agent, if there was one, have to support this as well, where the owner would have to collect a tax. I think the tax was supposed to be something like 3%. Also in there was the prospect that that meant they had to report to the state all of their rentals, and by so doing they would allow the town to add another 3% by which any funds raised by that, specifically in that proposed bill, was to go to any help defray the cost of enforcement of this new law. It did not go through. So what I look at is I see that it appears to be an overreach to quote some of these definitions in the cease and desist order. However, and I have some severe reservations around the use of the transient definition. However, it is there, so it's potentially something that we could deal with. But the other concern that I had was that what we have, and let me ask the petitioner here, what I believe in your response, you said that the advertisement as shown represented a true and correct copy, inclusive of steps you took to avoid running afoul of the town bylaws. Is that correct?
This is a copy that was modified.
Right. So you provided a copy of the current ad and said that this was modified to show that the intent was not to go astray, right?
Yes, but let's make it clear. I mean, I looked it over in terms of some legal issues, but one of the things that was a major concern was the representation I made regarding having running this function to the parties who don't want 15 cars or 400 cars. So that was one of my main focuses regarding that. I think certainly we wanted to be upfront about what he was doing.
Right. So what we have in the petition to alter the cease and desist order is your difference of opinion on the definitions, which I at least agree with some of those. I have a concern, however, in the respect that most of zoning laws, since they came into place, were an attempt to provide people an adequate place to reside, have community, safety, and all that sort of stuff, by which anything that you'll read will say that the residential definition is the highest use of the land. Do you agree with that?
I would to a point. I mean, there's an interesting history about all of this. I mean, there used to be elderly women who used to make their livelihood dependent on operating a regular room. You have cities like San Francisco, as you pointed out, who are concerned about the availability of markets. There's a bunch of different policies here. I mean, my argument to you is relatively direct. This is not a hotel.
Right.
Definitely, this is not a lodging house or a rooming house. That qualifies under 5.15 as an accessory use. And you know, there is place for a special permitting process in the context.
Yeah, it more or less does. And the case that you referenced of somebody renting rooms is specifically allowed in our bylaws. But what I have a concern about is a couple of things on your current advertisement represented as a true and correct copy. There's a couple of items on it. First of all, there are 4 reviews. I don't know if you can stop the reviews on there, but the most recent, I think, was as of 7/15. And reviews for the current advertisement, excuse me? But they're on your current advertisement, so that's what's out there right now. So the question I have, and to the board for consideration as well, relative to the use of the property and whether or not it falls within the residential definition as to the intended use, is that the reviews have stated things like, of course, the host is very responsive, helpful, etc. But specifically in, I think it was 12/15, this was a great place for an off-site business meeting by our executive team. We conducted business there, etc. 2 or 3 of the reviews, and whether you control that or not, I don't know. But that's the ad that's out there right now, saying apparently it's available for business meetings, and here's a testimony to that effect out of the 3 or 4 testimonies that were there. And the other, well, 1 second, I got one other point to make, and you can address them both. The other one is when you talk about the rules of the house, you do talk about 7 beds, 5 bedrooms, accommodates 11. And to the point of commerciality, what I have a bit of a concern with is then if we're renting the house for vacation usage, obviously within a broad definition of family type of thing, I move out and the family can enjoy it to the utmost. I have a bit of a concern in the respect that one of the rules is that there's a price of $150 a night for people after 4 guests. If I use a broad definition of a family, I would tell you what my family comprises of. You got 5 bedrooms, and I decided to rent that for my family. I think I would fall under that category to say, on what basis are you charging me more for extra people? That sounds more like when I book a hotel and it says how many people are staying, 1 or 2, and the price changes. I'm not saying that that supports the definition of a hotel, but what I am saying is that both the reviews that you're putting out there for people to see as a true and correct copy of today's current ad, and the rules of the house for charging the head counts, both of those items smack to me to be not something that would commonly be seen in a residential area.
So in terms of my response, let me make a distinction, because when I did this new ad, I did it real portal. What I meant by that statement, to be precise, is the content. So the issues that you're pointing out relative to price, that's part of the current ad, and I can certainly understand your point. In terms of the reviews, I would have to look and see if the reviews are on that site or not. I have, and I made this very clear, and I think it was my responsibility. The issue of corporate or parties or functions is something that has been removed. It's been there in the past. I would say this, and certainly if the ZBA wants to pursue this course of action, we're happy to sit down with Inspector Roberto, who wants to go a little further in the investigation, and provide all these records and show them what's been done. If you feel that the serial versus irregular issue is in regard, so we would be happy to do this.
Okay, I have a little less concern over stipulations on how one rents a house, because without specific bylaws to the contrary, if we were to say you can't rent anything for less than 30 days, I have no idea in this town how many people might rent their house for a week, 2 weeks, vacation swaps, all that sort of stuff. So if we interpret that strictly, we would need to make sure everybody in this town knew, and that their neighbors could call on them to tell them that they're breaking the law. We'd have cease and desist orders all over the town, conceivably. We just don't know. The other point that I have under your house rules, and I'll try to come to a conclusion after this, those reviews are on the material you provided. So I'm taking that as part of your petition. House rules does say no parties or events, so that's a good thing. And right underneath it, it says small family reunions, corporate off-site meetings, photo and video shoots are welcome. That strikes me as commercial application. The specific was Shirley, who said, I booked Alex's home for a business off-site meeting for our senior executive team. Skip a line or two, it says that following up on afterwards to inquire if everything with our stay had been okay. Our team was delighted with the property, finding it extremely comfortable and suitable for working from. So my concern is that if we were to perhaps alter the cease and desist order in some way or another, how we might do that, make sure the definitions that we had are supportable by law and within our interpretation that's not whimsical or arbitrary or whatever. But your ad, while I don't want to say you can't do an ad, because you couldn't do anything in that case, the ad does characterize the house, to my way of thinking, to a commercial application. And I suspect that if I were to at least make my feelings known to the board, I'm in favor of amending the cease and desist order and keeping it in place. But I think that the transient definition and the other definitions already used are not strong enough to curb certain activities. However, I would be much inclined if there was something that basically just said that the building inspector found that there are uses of the house that are not residential in nature, and the cease and desist order should command that any activity in the house fall within generally accepted definition of residential. I would offer that as a potential amendment. Any comments?
And so how would that play into the issue of whether or not he can rent out his house to 5 people or less, which seems to be what Attorney Reardon requested in his brief?
My understanding is that we don't have a strong enough thing to say that we can't rule on the boarding house or lodging house specifically, that some of that would be allowed, but subject to enforcement if they found that there was more than that, or private parties or video shoots or other things of that nature, the petitioner would be in violation.
I guess I'm still a little hung up on 5.1.5, which speaks to renting rooms. And my plain English interpretation of that is renting rooms kind of separately as opposed to renting the entire house. 5.1.5 put us at rent the house, but instead said rent rooms or cable board. So I'm still struggling to see the provision within section 4 of the zoning bylaws that permits an Airbnb rental.
Just one brief question. I noticed in the advertisement it stated 5 bedrooms. How many bedrooms are legally permitted in that particular dwelling?
My understanding is 5.
Okay. And I hate to put you on the spot here, Jack. You wouldn't happen to know, as far as the building file is concerned, if it's 5 bedrooms?
That actually would be Board of Health.
Okay.
The building, the septic system is designed on a number of bedrooms and also a number of rooms.
Okay.
I don't know what's inside.
Thank you. Okay.
Okay, I was just about to offer to the public, if you have something that is germane to the legal questions at hand. Please identify yourself.
Mr. Chairman, you know what you say, repeat the question or go around the public. I think you have an obligation to let the public hear what you're talking about.
Yeah. Not speaking.
My name is Nancy Cernelia. I live at 4 Needham Road. And when Charlie Wills built this area of Townsend and Needham Road, he called it Rock Rimmon, and we all have deed restrictions. Now, you said something very interesting in the very beginning. You asked if there were any restrictions or anything. I don't know what's in those deed restrictions, but it might be something to investigate.
Point well taken. Attorney Mullen? Do you have anything to add?
I didn't mention earlier, though I did put it in the letter, that I don't see this as a case where there's an appropriate accessory use, because the house, when it is rented out as a whole unit, and the owner vacates the premises. I agree with what was said earlier, that that's distinct from the renting of rooms. I understand that when one rents rooms, one retains possession, current possession of the premises, but one or more rooms are leased out on a short-term basis, or leased out to somebody. And also, I wouldn't call this the furnishing of table board. The dictionary definition of table board is the provision of meals with or without lodging, and as I understand it, the owner does not provide meals And I think that the question is, it all comes down to whether there properly is or is not some concept of transiency versus permanency, at least implicit in our zoning bylaws. And I think that it can properly be read in there because you have to look to the Mass State Building Code and through it the International Building Code, which clearly distinguishes between 30 days and less occupancy and anything more.
I'm Jamie Cernelia. I actually live closest to you. I live on 6 Needham Road. And so I first wanted noted that if you have 3 acres of land, it's like a pie. I probably live 500 feet from your house, so I can hear pretty much everything you do on a daily basis. I probably could tell 6 times you had people over because there were parties going on every time it happened. So I just want everyone to consider that every time you rented it out, there were parties going on, and there were noise violations. So if this does pass again, we will certainly be listening for that. Yeah, I don't like any of the parties. If it's a noise violation, yes, absolutely. Absolutely.
Yeah, everybody's entitled to quiet enjoyment of their home, and there are rules about that. You can't restrict people having parties. Everybody would be entitled to do that, subject to the normal activity of the town. Did you want to make a point? Were you standing to be recognized, sir? Would you come forward, please?
Thank you, Wayne Perry, Trickett Road, Linfield. December 2015, the Board of Selectmen meetings, I stayed to the end, heard all the licensing in the 2 lodges. And having full memory, and I went home, I was asked about, I can remember the names. So I started doing some searching, can't be many, Linfield, lodging, I remember everything. And what came up was, I did searches for lodging Linfield in December 2015. And what came up was this man's picture. I have to print out in the PDF. Renting nightly $2,299, all nice standard rate. Weekly $9,165. Refundable damage deposit $1,500. Book with confidence, cancellation policy, and then a calendar chart running through May of 2016. The website is www.vrbo.com. It's down, but again, this is a PDF, and I couldn't figure out what was going on. So I sent this PDF and the link to Bob Curtin. He couldn't figure it out either. He tried developing one. So this printout is for you. The PDF is in the town's email files. That's when it was. It is definitely an advertisement for ongoing business. They're a little shaky on the address, but his picture's on. So I find the contention of limited in more or less random activity to be fallacious. It's pretty much an ongoing business being advertised. It may be a failed business, but it was advertised as ongoing business, online booking.
Okay, thank you. Is there anybody else that would like to speak specific to any of the legal interpretation?
Mr. Chairman, my name is Richard Dalton, reside at 200 King Rail Drive here in Linfield. I will restrict my remarks to comments that have been made either by board members or by the attorney here, Mr. Reardon or Mr. Styler. With respect to parties at this 8 Needham Road, let's be clear, all right? And I think neighbors will attest to it. There have been plenty of loud parties. This is an ongoing issue. You know, the isolated incident of the tragic death, that's one thing. But on an ongoing basis, it's been a nuisance. A lot of people did not complain because they were under the impression that they had a neighbor who was not too considerate of them and their quiet enjoyment. And therefore, there were very few calls made to the police to intervene. But for Mr. Stile and his attorney to represent that there's been few events at this house is a complete mistake. Secondly, I think it was you that mentioned impact on the neighborhood. I will tell you firsthand impact on the neighborhood.
Excuse me, can you use my?
I'm sorry.
Here's my hand. Thank you.
Excuse me, Ms. Okay.
Attorney stands behind. Attorney stands behind.
Oh, attorney stands behind. So, with respect to impact, right, and the representation that his house is so far removed. Well, if you go on Albany Way, all right, his house backs right up to a house that's occupied by my daughter, by my son-in-law, and their 3 children, ages 7, 10, and 13. After the incident, those 3 children did not sleep in their own house for a week. They were afraid to be in their home, in their neighborhood. You want to talk about impact? That was impact. I'm sure that tension was shared by the neighbors that are here this evening. Okay? So to address that, Ms. Stanziani, excuse me for not addressing your point. And I think finally I'd like to say that I've heard the word special permit being thrown around. If in fact a special permit for some reason is to be considered by this board, I would look at it as when you're the issuing authority of a permit, when you're the issuing authority of a liquor license or whatever, you look to the character of the individual, and I would say that this person is not of the character that should be issued a special permit. When you look at him being sued by Microsoft for using pirated copies of software, when you look at assault and battery arrests on police officers, those types of things go to the...
Object to the record.
Right. Object to the record, but... Mr. Chairman, I have the floor.
Let's try to keep it to stuff.
It is germane, special permit.
Well, we're not hearing this. Special permit.
Well,
is not
special,
before this board,
special permit has been addressed this.
but it's not before,
Okay.
we're not ruling on it.
Just my views.
Okay. So I would just say, I would urge this board to, this is an issue for the Needham Road neighborhood for sure, but it's also an issue that you hear every day in this town, and that's preserving the character of this town. And that's what this is all about. Thank you.
All right, so it's up to the board to come up with a decision. It is a possibility it is a burdensome task. We could put this off for another month, particularly if the petitioner agreed to it, but that would mean that the stay of the cease and desist order would stick until that point in time as well. So we have a number of comments made, a number of legal issues. Yes. If it's germane to the legality of the case.
I'm a resident as well as a realtor, so I just brought up our town assessor's report on this property. Ellen Crawford. It's listed in our assessor's public record. It's a 3-bedroom, 4-bath home, and the owner's address is listed at 239 Commercial Street, Malden. Well, it just lists the assessor's record as your owner's address.
All right, thank you. Comments?
I guess I remain of the view that I don't see a provision under section 4 that permits the rental of the house, as Mr. Stiller proposes to do. I don't believe it constitutes rental of rooms under the accessory uses of 5.1.5, and I don't see anything else in section 4
section, I don't see any other provision in there that would enable the use that he is requesting to do.
So are you prepared to make a recommendation to the board to act on cease and desist order?
Well, I don't know what your views are, but that's my view.
At this point, I would move to uphold the cease and desist order. In reading Attorney Mullins' report, opinion, I would agree with Attorney Mullen relative to our ability as far as the cease and desist order is to continue to prevent the use of advertisements and however, I don't believe we have the authority to do so. And I would say we would just modify the cease and desist order, removing that one portion of it. Well, the cease and desist order, it specifically spoke as to the advertisement of the premises. I don't think we can limit the advertisement, and I'm in agreement with that. I'm in agreement with the cease and desist order as far as the use of the premises, but as far as the limitations of advertising, I do not think that we can do so.
Okay, so also in Attorney Mullins' letter was a suggestion that some of the terms that were used are not strongly supported in hanging the cease and desist on the definition of transient use. So if you're suggesting you want to uphold, you're really saying you want to amend the cease and desist order, and I think we would have to then take all the reference out to it being a hotel or a lodging house or anything else like that, but just to say that the use of anything that constitutes transient lodging per this definition by 2015 IBC would not be allowed, and that's a much simpler letter, short of providing them the opportunity to come back before the board if they so desired to perhaps request a special permit as a, the term I use, lodging house. Does seem to be consistent with the IBC definition of lodging as a one-family dwelling where one or more occupants are primarily permanent in nature and rent is paid. The question is guest rooms, which we would have to interpret at a later point should they follow that path. But some aspects of it is obviously primarily a single-family house used, however, for parties or anything else that people can do with their single-family house. That's of a right for the owner of the house. But the reference to board, currently in the cease and desist boarding, lodging, hotel, and even I think perhaps any reference to commercial should be struck in favor of just quoting the transient definition.
Yeah, just, I guess my only question, I just would want to hear from Mr. Mullen as to whether or not what you proposed is, whether he believes that's consistent with his analysis and supportable by his analysis.
Yeah, I think it is. As I understand it, the proposal is that the board would vote to uphold the building inspector's cease and desist order, but on the basis that any transient rentals are not an allowed use in the single residence zone. And to the extent the original cease and desist order purported to bar the advertisement of any rentals, that would not be upheld. Am I right? Have I got it right?
I wouldn't use the word uphold because we'd be amending, dropping some of those specific terms.
The transient definition is going to cover what they can do, and that says you can't rent for less than 30 days, and you don't need the specific definitions which aren't there for a boarding house, hotel, or lodging house. What you're saying is you can't rent it to occasional guests for anything from 2 to 30 days under the definition of transient. So that would simply amend the cease and desist to a very simple paragraph quoting only that. And why put something in there that's hard to defend by existing definition? Which of course we'd ask you to do that, but that's what I would propose is that we can uphold, which means as is. We could suspend it altogether, or we could amend it. That's what we're allowed to do.
I guess, again, I'm going to defer to Mr. Mullen on what the board has authority to do. I think we're in agreement on what we want the result to be. I don't know whether technically we're upholding the order on amended grounds or we're amending the order, and if it doesn't make any difference, then that's fine. But if we're limited to either upholding it or rejecting it, then I think we have to uphold it on amended grounds.
Specific in the law is you can withhold, you can support it, deny it, or amend it. So, unless Attorney Mullen has a different interpretation, it's fairly clearly spelled, I think.
So I would second your motion.
My question is,
So I understand that there's a second part of the request by Attorney Reardon that you asked this board to stay the order pending your appeal.
Yes, I did.
You did, okay, so that's my question to Attorney Mullen, if we have that authority. I'm not sure if we do.
My understanding is the order has been stayed because it's been the practice of the building inspector to not enforce cease and desist orders if there was an active appeal. This is the active appeal. We're acting on that tonight. Is that anything different? Interpretation?
The building inspector has a policy, which I think is a very good one, of staying his enforcement hand pending any property owner's appeal to this board. Whether your board chooses to stay after you have ruled is an entirely different matter. I'm aware of at least one other town, the town of Stowe, which has taken the position that they don't have the authority to stay their hand after the ZBA has ruled. I'm not aware of any legal authority actually one way or the other. I don't believe that the issue has come up previously in Linfield.
I think it depends on the petitioner's intent to come before us on a special permit after our ruling today.
so my understanding was maybe Attorney Reardon that he was going to appeal this decision. That was my question.
I appreciate it. I think it's, you know, I have an obligation to ask you to stay, so I can ask somebody else to do the work. I think the answer to your question, the legal issue that you're sounding around this thing is going to take a little bit of analysis in terms of whether you want to start whether it would be viable. If the board does rule tonight, I would ask you to stay either until it happens and we have a reasonable time to consider the amended order, because that's what we're looking at. But I appreciate your consideration of that.
Well, my question would be then, if it's an amended order, the order is still there, right? Is that treated as a new order that then provides the same appeal period? Otherwise, we could change the word every month and have an appeal every other month.
I don't like this terminology about amending orders. Basically, there is an appeal before you from the decision of the building inspector. You either uphold it or you deny it. And you can uphold it, as I said earlier, on a ground other than that advanced by the building inspector. Once you issue your decision, there's no question. Either the order remains in effect or it does not. And you can, as I also said, you can change the contours of what is being prohibited. I did recommend that you not purport to prohibit the advertisement, as I don't think the building inspector or the ZBA has that authority. But no, you do not start a new 20-day or 30-day appeal period to your own board. What you do when you file a decision with the town clerk is you start a 20-day appeal period during which the owner may appeal to your decision to court. That's not the building inspector's decision, it's your decision.
Okay, would you care to rephrase the motion?
Not really. My initial motion was as to the use, the current use of the property being prohibited by the building inspector's cease and desist. I wanted to uphold that cease and desist as to the current use. I believe from that point forward is when we started to define the current use in using language as far as transient is concerned. So I'm not sure that my motion can be seconded until we further define that. If you're following me.
Yeah, I do follow. What I'm reacting to is the petitioner was very specific in asking this board to reverse certain statements that weren't founded in law to the extent necessary for an explicit definition of boarding house, hotel, or lodging house. And the answer that we have back from town council says that with the verbal just saying that we would uphold it, I don't know how we uphold something if we're basically saying we agree, then that is a boarding house or a hotel, when we've introduced new information with a definition that wasn't in the original, that talks about transient use and is in many ways broader than some of those other definitions. So, I'm at a loss as to why you would uphold something that doesn't seem defendable versus amending it to something that is more clear and obvious in its intent.
No.
Well, we need a motion.
Well, I think we had a motion before to amend the order, and I think that motion was seconded, so I'd be prepared to vote on that. And then I still think we need to address the second question of if we uphold the order or amend the order that prevents the use that he would like to make of his house, we have to deal with whether or not we want to stay that amended order pending the appeal period to a court. So if we can get the first motion out of the way, then we can come to the stay issue.
I understand that you're in the process now of doing this issue with the legislative part. May I make a procedural suggestion?
Sure.
Before you do that, I think one of the other options relative to making it easier and cleaner for both of us would be to continue it and allow the inspector to make his own. And we waive any additional notice and we just come in to make that point. We need the opportunity to address the issue which was raised on Sunday. I don't criticize this right now. If we resolve all the issues and we make a final argument, and I think we could have likely between Attorney Rowland and Inspector Roberta something that can be dealt with. And certainly we would waive the appeal period as long as we can rely on the petition.
So you're suggesting we not resolve this tonight and defer it?
Yes, and with the expectation, it's essentially an invitation that rather than you amend the order, the building inspector does, and we'll waive the additional notice and just use our petition.
And what about rental of the house in the interim?
I can tell you that Mr. Steiner has one for rent. One of the reasons I asked for the stay, it's a very short-term thing. I mean, I don't want to put my client in a position of losing that. That's why I asked him to stay in the first place.
You've had to stay for 2 months, and to me, we've discussed the issue, we've reached, I think we're close to reaching a consensus on it, so I guess I don't see grounds for continuing to stay the order.
Well, this is what I would say to you in terms of trying to resolve it with the building. The sporadic nature of these is a deep book, long range. Mr. Styler has booked one. It's my understanding, although I have to check with my client, Mr. Styler has not had any money in the premises since the incident on the 29th. I just think in fairness, it was a suggestion. I have no choice but to ask the first day, or go to a judge and ask the judge first day. But what I did propose was I think a responsible way to deal with the issue that you're struggling with. In terms of wanting out my client, I certainly don't want to see him have the issues that are likely to arise tangential to losing a booking, trying to book 12 days. But this is within the discretion.
So not that I feel it's terribly germane, but is that booking to occur in the next 30 days?
My understanding is it's the 8th of August. Is that correct? Yes. And the length is 2 days? 1 week.
It really doesn't enter into the decision except for potential hardship or you to come back another legal avenue at some point. However, it has been the position of the board to allow continuances for permitting, etc. And my understanding of enforcement issues is that we can do the same if the petitioner has requested that and waived the timing, which the petitioner has done. So it's really up to the board. As my understanding, if I restate what you're saying, the purpose, like we do in other permits, etc., we ask people to redraw their garage and put it within the specs or do something else that we want them to do. What I understand you're saying, correct me if I'm wrong, is that we will set here the expectation that the building inspector is going to work with town council to come up with the language independent of trying to wordsmith it here tonight. And 30 days from here, we'll have that. And in essence, we're basically saying which way we're going to go. But we want to see like the final drawing, final plan, something like that, in which case the current activity of the building inspector to not enforce would probably come into play, because we'd simply be granting a continuance from tonight's activity until our next meeting.
I certainly would request that, and you would give me the opportunity to be prepared to make a response to the argument on transit, which I think you deserve.
See, what I don't want to do is just defer this for a month and start again in the discussion. If what we're talking about is Mr. Roberto and Mr. Mullen working out language that we later review, then I could be amenable to that. What I'm not amenable to is just another hearing on the same issues that we spent the last couple of hours on.
Well, and again, I've heard the position and I respect it. I went by an order that didn't mention this issue. I received first notice of that on Sunday night. So when
Your brief addressed this issue. Your brief talked about 4.1.10 and 5.1.5.
No, you're doing something a little different. What you're saying is Mr. Snyder's neighbor did not have any transient premise whatsoever. That's what you're saying. That's not the basis of the decision that the inspector had. I understand the point, and I understand what you guys have made yourself very clear. I do think we're entitled to make a legal argument. I propose a way to do it. That removes the notice issue. I understand what the feeling is. I've also pointed out we incorporated some of these quotes. So I would request that. I don't think there's anything else we can do more to this point.
As far as Mr. Reardon's point is concerned, I think if the building inspector is willing to redraw that with town council, I would be in support of that. So we have a better definition as far as what the cease and desist, given the testimony this evening, covers.
But that's different than opening it up to further arguments.
Relative to the definitions that are in our cease and desist order.
Correct. What I'm understanding you to say is that Mr. Roberto and Mr. Mullen work together on the board.
Correct.
Without the participation of Mr. Reardon, the ability of Mr. Reardon to make further arguments.
To craft the order without an open meeting.
Yes.
I wouldn't think that we would be able to craft the order without open meeting. I think that the order would, unless I'm wrong as far as town council is concerned, I I think the order would be crafted between town council and the building inspector. The order would be provided for us, and we would stand behind that order, and would be provided to the petitioner.
Provided to the petitioner as a final signed order, or an order to which he's entitled to make arguments in the Supreme Court?
I would think I would think he'd be able to appeal the order.
Well, appeal the order to court. I'm trying to figure out whether our process is ending here tonight, or whether we're coming back to another zoning board meeting in which we further debate the contents of the order. I'm just not trying to argue with you, John, I'm just trying to understand what your suggestion is.
May I respond?
Well, can I hear John first?
Absolutely.
I would think they'd be able to come back before us as far as the order is concerned. Not to revisit the order itself as opposed to revisiting the original order. They could further appeal it to, well, I think we're continuing.
Appeal it to court, but I'm talking about
Yeah.
the process before us.
I believe we would be continuing the matter to next month. I believe the order will be crafted, this is how I'm seeing it, the order will be crafted by town council and the building inspector. Our matter is being continued to next month as far as the order is concerned.
And what is open to discussion next month? Next order?
I believe it would be,
Okay.
unless town council,
No, that's right.
okay.
So I have a question for the board.
I don't know if we can resolve it today unless we, from my point of view, I believe it would be a haphazard manner if we did, in fact, start recrafting the order as we sit here today in terms of putting definitions in it and limitations in it, without town council and the building inspector looking at it.
So John, I have a question for the board.
How are you going to decide on his rental if you're going to continue us to next month? Mr. Styler has a rental in a week. How is the board going to address that?
I believe the chairman spoke as to that a moment ago in terms of almost like any other continuance that we've done. In terms of almost any other continuance that we've done, although this is a different situation because it was a cease and desist. But I think we're in the, I think the rental that is upcoming would be able, as a matter of course, since the building inspector is chosen to continue it until our hearing, it will be continued to our next hearing, and they would be able to rent it at their own peril.
I understand as well.
That's a question for the petition.
Right. They're curious as to when you took the booking. And again, I don't think it's that germane. What we're talking about is the legal ramifications that we have to find against or for the petition. And the current situation is there's a cease and desist order which is stayed by the building inspector, so it's less relevant. I'll appreciate it, but as I said in the beginning, what we're bound by is the laws and the personal aspect of it, not germane. Right, you're absolutely right. We can't make a decision tonight because we don't have a legal basis to do so. So we're going to do that in the proper way and take care of it so there is less potential for liability to the town continuing a situation that's obviously been going on for 6 or 9 months and just came up because of the unfortunate situation that arose recently. So, you know, folks that are in the neighborhood, absent of deed restriction, which we don't know about, or any homeowners association which further restricts activities in that area, you're all entitled to have parties, you're all entitled to have guests, you can have your in-laws stay over, have a cookout, all that sort of stuff. So there is no basis for us until we find the right language supported here by a legal counsel to determine it in a definitive way, which the board is suggesting. We're continuing, as we do many items, that are contentious and difficult to resolve, because we're not going to sit here and wordsmith something that was prepared by the two folks sitting at the end at the request of apparently a selectman to do a cease and desist order. So we're trying to clean up what the improprieties are in some of the definitions here that don't seem to apply. So what we do have is more likely to stick, okay?
And I'm going to go back to my first comment of the evening where I don't want to look at this in terms of a response to a tragedy. It's a response to a zoning issue. Just as somebody using a property as they're not supposed to, as a multifamily dwelling in a single-family residence, as a accessory use when they're not supposed to be having an accessory use. I understand there was a tragedy, but I'm also trying to look at it in terms of dealing with the zoning issue and the use that we're currently dealing with. Point taken.
Okay, so, well, you know, you should go back to this then. Would you restate what we're going to do? The petitioner has asked for a continuance. You can vote on that and give the marching orders.
I would grant the petitioner's motion for a continuance for 1 month, and in the interim, our building inspector as well as our town council will craft a more definitive cease and desist order, which will specifically define what is being ceased and desisted, as well as removing the mention of prohibition relative to the advertisement relative to the property.
A motion made and seconded. All those in favor? Aye. Okay. Grant the continuance to next month as stated. Thank you.
Thank you very much.